Ready, start. The trial court committed an error in conducting the joint trial of the respondent numbers 1 and 2 despite the case not falling within the conditions stipulated in section 223 of the Code of Criminal Procedure 1973 for conducting joint trial. The High Court observed that the trial was bad in law, as the respondent numbers 1 and 2 were accused of committing different offences committed at different points of time, and the joinder of trial had caused grave prejudice to them and led to miscarriage of justice. The High Court emphasized that in addition to the procedural infirmities that resulted from the non-compliance of Section 223 CRPC, there were major inconsistencies in the deposition of prosecution witnesses. However, it clarified that the conviction was not set aside solely due to procedural lapses. As per the principles laid down by the Honorable Supreme Court, and the two-pronged test satisfies this case that the joint trial conducted has prejudiced the defense of the accused and has successfully proven to cause a miscarriage of justice. We are of the view that the prosecution has failed to prove the case on various grounds. The conviction of the present appellants is not being set aside on the mere ground that the procedure of section 223 of the code has not been adhered to, but there are numerous laches on the part of the prosecution in proving the case beyond reasonable doubt. The learned trial court has also failed to consider the fact that Section 223 was applicable in this matter, but the same has not been considered in this case, and the appellants have been tried jointly, causing prejudice to the appellants, despite which the learned trial court has recorded the impugned judgment of conviction and the order of sentence. As such, the same are required to be quashed and set aside. Taking exception to the impugned judgment, learned counsel on behalf of the appellant submits that the High Court fell in a grave error in concluding that prejudice was caused to the respondent numbers 1 and 2 due to non-compliance of Section 223 CRPC. He submits that the ground qua non-compliance of Section 223 was never taken by the respondent numbers 1 and 2, and the High Court examined the same on its own. To buttress the submission, it is submitted that even if Section 223 was not complied, it did not cause any prejudice to the respondent numbers 1 and 2, and they had sufficient opportunity to participate and defend themselves during the trial. It is further submitted that the age of the victim was established to be under 18 years without any doubt on the strength of the school transfer certificate statement of the victim under Section 164 CRPC and the medical report dated 1/7/2016. It is further submitted that there was no reason to doubt the testimony of the victim, and in a case of this nature, the testimony of the victim could form the sole basis of conviction.